Thank you for being here.
Thank you.
Ms. Bent, right? You're the president of the Ontario Trial Lawyers Association.
Yes.
As you probably heard, you have 10 minutes for your presentation, followed by 5 minutes of questioning. And this round question will be coming from the official opposition party. You may begin any time. When you begin, can you please identify yourself for the purpose of the answer? Thank you.
Certainly. Thank you. Hello, I'm Maia Bent. I am the president of the Ontario Trial Lawyers Association, and I am also a lawyer in London, Ontario, practicing at the law firm of Learners. I have almost 20 years of experience in representing plaintiffs who have been injured primarily in motor vehicle accident cases, so I have seen firsthand how the auto reforms have a real-life impact on the people of Ontario. Auto insurance is mandatory, and therefore it has to achieve a balance between competing interests. We consider them the 3 Ps. There has to be consideration of premiums, of protection, and of profitability. Premiums must be affordable for consumers. There also has to be coverage protection so that insurance is there for people when they need it. And insurance companies need to be reasonably profitable. So an analogy might be a 3-legged stool, and if any one of those interests is out of whack, the entire product will not function properly. Now, we've had almost 2 decades of insurance reforms, and almost every reform has eroded coverage for innocent accident victims, and premiums have remained stubbornly high. And this is unclear because the insurer profits are very healthy. A report that was done by 2 York University professors, Professors Lazar and Prisman, show that the insurance industry is very profitable, but these profits are not being passed on to the consumers. They show that consumers have overpaid by $840 million and $702 million in the last 2 years for which they had data, and that in 2014 the insurers were making a return on equity of 10.6%, which they felt was double what was reasonable. The erosion of coverage to accident victims means that we are now at a place where the automobile insurance system is fundamentally broken. The multiple reforms have given us an unwieldy, bureaucratic system that is not working for anyone, least of all those who it was designed to protect. The appointment of David Marshall is an opportunity to reboot the entire system. And if the government is interested, the Ontario Trial Lawyers Association has many ideas on things we can do to rethink the automobile product. Today I want to highlight just one problematic aspect. The culture of claims denials makes it difficult for injured people to access the few benefits that they have left. And for those unfamiliar with the system, an injured person must first submit an application for every treatment that they need, for example, 8 sessions of physiotherapy. And this form is filled out by a medical practitioner, such as a family doctor, and that doctor has to certify that the treatment requested is reasonable and necessary. So the insurance company already has medical data that this treatment that's being requested is in fact required and legitimate. Despite having this information, approximately half of all claims are turned down at first instance. This gives the injured person a choice. They can either withdraw their claim or they can submit to an insurer medical examination. Now, injured people tell us how difficult it is to be repeatedly subjected to these examinations, often in other cities by unsympathetic and skeptical doctors. And this is even worse if the assessor is assessing them for a disability that comes from a psychological or a psychiatric problem, and they're forced to talk about their feelings to somebody who is there to evaluate them in a skeptical manner. In addition to these examinations, the insurance company also has the right to send claimants to medical examinations as often as is reasonably necessary. That's the language of the legislation. Now, a couple decades ago when I started doing this, the rule of thumb was about once a year per problem. So, for example, a psychological problem or a physical problem. But since then, there has been an explosion in the frequency and number of these examinations. In my practice, I have often received requests for 5, 6, 7 medical evaluations, all to take place within a 2-week period. And if a person objects or refuses, the insurance company labels them non-compliant and terminates their benefits. So my clients tell me they can't survive without their income replacement benefits or their medical benefits, and they often give in, even though our advice to them is that those examinations are being held more often than is reasonably necessary. So when the medical reports do arrive, they are frequently negative and support the insurer denials. As Justice Cunningham stated in his review of the Ontario Automobile Insurance Dispute Resolution System, he said that the problem was obvious, and his quote is, "An expert retained by an insurer who supports claimants is unlikely to be retained again," unquote. Now, at the end of it all, I have discovered that injured people are often angrier at their own insurance company than they are at the person who hurt them. They feel betrayed by the company that was supposed to be there as their safety net if something bad happened to them or someone they loved. Medical examinations are not being used to fairly evaluate claims. They are a systemic barrier to injured people who are trying to get insurance benefits for their legitimate injuries. And all of this adds cost to the system. The insurer's own data shows that for every dollar paid out for treatment, 70 cents is being paid for medical examinations to deny treatment. One simple solution would be to legislatively limit the number of medical examinations and the frequency of those examinations. This would save cost in the system, it would speed up claims handling, and it would remove barriers to injured people who are claiming accident benefits. And this is just one idea that we have to assist in a reboot of the system, which we are strongly encouraging the government to consider. We need to move the focus of the conversation about automobile insurance to what happens to claimants once they go into the system. The conversation has been very heavily weighted on the premiums and bringing premiums down, but there's no point in even having an insurance product if it isn't going to be there for the people who need it. We need to achieve a balanced automobile system, and we need to rethink the priorities around that. And I'm happy to entertain any questions.
Okay, I'm going to turn to Ms. Martol to begin this round questioning.
Thank you very much, and I think it's very timely that you bring up that doctors' reports are being often ignored, because we're just seeing in the news the past week or so that there's complaints about WSIB, the Workplace Safety Insurance Board, that also a lot of claimants feel that their benefits are denied because their doctors' reports are ignored. And the doctors themselves, I think, have created a group and are speaking out against that. And we have to, sort of question ourselves as a society what we mean by ignoring doctors' reports. Are we suggesting that the doctors are some part of some elaborate fraud? We just, just think that a bureaucrat knows better. So my question to you is, what would you suggest in terms of what could be implemented so that doctors' reports are taken seriously? Would you advocate maybe not, I know you're advocating fewer doctors' exams, but would you advocate for a system where, the doctors' reports have to be taken more seriously? Maybe that would facilitate having fewer exams.
Well, the courts have recognized that a doctor who sees somebody over a period of years, such as a family doctor or an expert or a treater who's been working with the person, has a far, far better grasp of their their issues, their disabilities, then some so-called expert who's been hired by one side or the other and came in on a one-time basis. And in the courts, the shift has been to put more and more weight on the people who actually have some continuity and really do have a chance to get to know you. I think that, unfortunately, it is an adversarial system that has sprung up, and I think that, as Justice Cunningham said, a doctor who gives a report repeatedly in favor of a claimant instead of an insurance company is unlikely to be hired again. And I'm not suggesting that there's any wrongdoing necessarily, but I think that different practitioners have different philosophies, and the insurance companies, and they seek out people who support the views that will assist them financially.
I agree. Well, I just think that the doctors feel very disrespected in the province, and things like this aren't helping. In terms of, the government trying to cut down insurance premiums, what we've heard from other committees, I'm on the Social Policy Committee usually, is that coverage is being cut, that instead of $1 million, $2 million for a serious accident, say somebody is unfortunately becomes a quadriplegic, instead of $2 million of coverage, that the government is cutting it to $1 million allowable for coverage, and people don't find out about this, unfortunately, until it's too late. They don't read the fine print. So is that sort of what you're also advocating, is that you want to see better coverage?
Absolutely. This has been a problem that has been coming for a long time. I mean, the most recent round of cuts have gone into an area which had not been touched before, and that is the issue of the people who are catastrophically injured, the most seriously injured people. These are people whose problems are not going to disappear with the elimination of coverage. You're simply downloading that cost onto the public health care system, and it is a very, very worrying problem. But for people who don't achieve that level of designation, catastrophic impairments being harder and harder to qualify for all the time, there are a lot of extremely seriously injured people who are in a much worse position because their coverage has been eroded down to almost nothing. If they're fortunate enough to have a claim, I mean, they may many years down the road get some financial remuneration that way, but a lot of people are simply out of luck.
Has it ever been suggested, instead of using the court system, which is so costly for the insurance company and for the patients, to have some sort of more of a mediation for some of these claims? The way we've tried to take some of the family law out of the court system and things like that, by trying to say we're going to cut insurance premiums, which, let's face it, it's a capitalist market for insurance, and the government didn't go the route of what the NDP had suggested under Bob Rae, and he backed out, is to have, no-fault insurance or something. I'm from Quebec, so that's what we call it there. Is it feasible to, to have some kind of a mediation to cut costs?
Can you make your response brief?
Yes,
because we're running short of time today.
The mediation does exist in the system already in many different aspects of it, and it is widely used, but mediation is only effective if the parties are there with a willingness to settle. Mandatory mediation hasn't worked very well because it's created another step that people have to go through, and a lot of times, the insurance companies show up with no offer.
Okay, Ms. Bent, thank you very much for your presentation as well as the written submission.